All right, everyone, another victory for the Second Amendment pertinent to Bruin and ongoing arguments. The Oregon Supreme Court has rejected the attempts by the state government there, using a ballot initiative, actually, Measure 114, to ban magazines that hold more than 10 bullets. I'll get into why that's especially problematic. To force people to get a certification and take like a training course in order to buy a firearm, expanded background checks, the usual anti-gunnery. Oregon, of course, is a deep-seated blue state at this point. It used to be, back when I was a kid, the Pacific Northwest was swing territory. Republicans would bother to campaign in Portland. Now, I don't think it's wise to show up there with a MAGA hat at all. I don't think that it would go over too well with the native population, which seems to face absolutely no repercussions for any degree of violence and vandalism and arson. Meanwhile, they want to take guns away from law-abiding citizens, probably so they can be abused more easily by Antifa and BLM and other thug groups like that. Now, what happened here, link in the description, archived of course. The Supreme Court is not saying that the law is illegal, that the measure that would be imposed, creating a law, would be illegal. What they're saying is that the Supreme Court at the state level is not going to alleviate the block of that while arguments continue. It's currently being decided in a lower court there in Oregon. Only once a decision is made can there even be a grievance where the state Supreme Court would be able to take it up. It's not their jurisdiction yet because it's an ongoing case. What they're simply saying is the measure can't go into effect at the moment. I would hazard a guess, it's just an inexplicable feeling that I have, that a shit ton of people in Oregon right now are using this grace period to buy more firearms. I'm not sure if it grandfathers it in, by the way. You know, you got a bunch of 30-round mags, and they say, well, we're not going to touch the ones that already exist. But it's unenforceable. Also, it's a bit technically unenforceable at this point to have a mag restriction anyway, because anyone that wants can fucking 3D print one. Of course, you can do that semi-legally, depending on where your state is. It's a big problem. It's like in the state of Vermont. They have a mag restriction for magazines that hold more than 15 bullets for a pistol or 10 for a rifle. Now, this is a big problem because with some highly modular gun variants, the same magazine can be used in the pistol or the rifle variant. So, for example, in the state of Vermont, this is not Oregon, I'll get to their particular restriction and why that's even more stupid in a moment. If I go to Vermont right now and I buy an AR pistol variant and an AR rifle variant, and I get 15 and 10 round mags, I can put the 10 round mag in either one of them. Perfectly legal under state law. The state law being blatantly unconstitutional. I'm not sure if there's an ongoing challenge against the Vermont State Supreme Court's stupid decision, by the way, at this time. I wish that one of the gun groups would bring one up. But if I take the 15 round magazine, I put it in the pistol variant, it's fine. Nobody cares. That's perfectly legal. The second I put it in the rifle variant, all of a sudden I'm committing a felony. And so if I have a bunch of 10 and 15 round mags around, if I even have the 15 round mag, but I happen to have the rifle variant capable of taking that mag, capable of being fed bullets by it, the state police might show up and query me and say, well, we got a tip, wink wink nudge nudge, we're not sure if it's actually true, that claim, that you put the 15 round mag in the 10 round mag gun. And so we're going to detain you, take these guns, red flag law kicks in, etc., 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 and then you have to litigate against a state that has limitless amounts of legal resources to defend yourself from potentially felony charges without having done jack shit. So, to my fellow Vermonters, of course, if you have the pistol and the rifle variant, you may want to be careful. Oregon's law is somehow worse. That would restrict it just to 10-round magazines, so super low capacity magazines. Of course, 15 is already low, unless you're using it with a handgun. Then it's okay. It's like, I've got a Glock 17 at home. It takes a 15-round mag. That's fairly standard. It's like this type of weapon that police use, actually. So it's serviceable. It's a decent weapon. Highly reliable. I like the way Glocks look. Some people say that they look too blocky or too spare or brutalismist or something. I like the look. It's an iconic weapon. Shut the fuck up. It's also really good. Their law would be even worse, though. If you restrict to 10-round magazines, a shit ton of the handguns that are currently on the market suddenly become unusable without modifying the magazines to limit the amount of actual bullets that can be in. You can retrofit the magazines to reduce the capacity. So you'll have a gun that doesn't have a 10-round magazine for it, and you have to modify that at your expense, by the way, while also buying their their training course, which I'm sure will be totally not pricey. I'm sure they won't jack up the cost of that simply because they can. It's not, again, sure whether this would be grandfathered in for people who already own firearms. Probably they will because it'll make them more money. It's basically a cash grab. I don't believe that upon further consideration, under the auspices of Bruin's decision, that it's enforceable. I can't imagine it passing that sniff test. Again, a lot of other state-level gun control, including in my home state of Vermont, could very well go the way of the dinosaur. The problem is you have to get a court to take the case up and make a decision in the first place. First, you have to have an aggrieved party. Of course, there's a lot of aggrieved parties to go around with anti-gunnery. Then they have to successfully get the case going through a court. A court can just deny a motion to hear a case. They can just say, I'm not going to hear it. It's not important enough. I just don't feel like it today. I've got a really full docket. We'll schedule you for some time in the next millennium. This has been the problem with the U.S. Supreme Court, too, in some cases. Their reluctance to take up cases sometimes is a symbol that they don't want to weigh in because they don't want to make a big cultural issue out of something that's a minor inconvenience. We see this a lot. Applause to them historically for doing so. There are some times, though, that they repeatedly refuse to hear a case or refuse to rule on a case and do anything, even when there's an egregious violation of people's rights. Of course, the civil rights movement did exist, libs out there. Just to be clear, this is a civil rights movement as well. Now, the ability of people to defend themselves is not really negotiable. The fact that this went through via ballot measure is even more inhumane when you think about it. The idea that a simple majority of the population, or those that bothered to vote in this case, not even a majority of voters, can rob weapons or rights from other people simply because it's a democratic vote, it doesn't really make sense either. Sometimes it's a judicial decision, sometimes based on old casework. Oftentimes it's legislation. Sometimes they try executive orders. Those go over really, really well, by the way, you may have noticed. This one's via ballot initiative. It just shows that the people of Oregon, a lot of them are stupid, unfortunately. So yeah, that will be blocked pending a final decision by this lower court. Only then, if the decision pisses someone off, and regardless of what the decision is, it'll be appealed, then the state Supreme Court can choose whether to weigh in on it. If I had to guess, I'd say the lower court will side with the gun owners. Effectively, that makes it a dead issue. If the lower court sides with them, it's not going to be easy for that to be overturned by the state Supreme Court. They may very well say, well, the ballot initiative voters aren't an aggrieved party. They're not claiming the removal of any constitutional right or anything, so we're just not going to hear the case. The lower court ruling stands. If they rule against the gun owners, though, they may be compelled to take it up because it's a constitutional issue. It's almost a win-win, regardless of what decision they make. I have a feeling the lower court will uphold the gun owners' rights and say, look, just because you had a democratic ballot initiative doesn't mean that you can endanger an aspect of the Constitution. It's like if the people were to decide, 51% of voters decide, hey, we don't think the email should be protected by the Fourth Amendment, so we're going to let the cops snoop through people's email and shit like that without a warrant. It wouldn't go over so well. And the liberals, by the way, would not be supporting such a measure and would be crying foul about human rights. Well, the ability to defend yourself is one of the main human rights, just to be clear. That's about all. Peace out.